Good evening, everybody. Thank you for taking time out of your busy evenings to be here. I know you have better things to do. I want to start by saying, if you don't know me, I'm Commissioner Richard Rothschild. Tonight's discussion is not about any commissioner. I'm not here to talk about any particular commissioners. I'm here to talk about a document that, in my judgment, has some serious problems. And one of the problems is that we get into these vague discussions about what makes a document better. We hear words like open, we hear words like transparent, but those are vague words like moving forward. Keep moving. It doesn't mean anything. And as a result of this, we are now in two polarized camps. We've got one side that wants to cram it through, another side that's trying to stop it. Now, I want to define a stronger ordinance. You have to be careful. The new ordinance certainly has more disclosures. More disclosures. Talk about the ethics ordinance, more disclosures, but it's not stronger, it's weaker. It's more disclosures, but it's weaker in terms of preventing conflicts of interest, and I will provide you proof of that tonight. Clearly, we need a better ordinance, as evidenced by the fact that we are seeing situations that make many of us very uncomfortable, where we have commissioners, not just in Carroll County, but in other places, like Frederick, voting on decisions that will fund collective bargaining contracts that benefit their own family members. Now, 20 years ago, 10 years ago, that was unheard of, and now somehow, with a new evolution of thinking processes, the unthinkable is now about to be codified if we don't take some action. So the bottom line is we do need a stricter ethics ordinance, but it's got to be one that's substantive, not one that just has the appearance of being strict because it has lots of irrelevant disclosures. So what I'm going to do here is I'm going to go through this. I'm going to explain it conceptually. I'm going to provide some examples. I'm going to show you a review of how we got here, how we fix it. But before we get started, and then when we're done, we're all going to go downstairs for the actual hearing at 7 o'clock. This is a dry topic. It's hard to take a 34-page ordinance that's thousands and thousands of words and summarize it in a few minutes, 15 or 20 minutes. So I've created a little video to give you kind of an executive flyby, and then we'll talk about it in more detail. So here we go. I hope you enjoy this little 5-minute video.
Harg, taxpayer. Welcome to the good ship, Ethics.
Captain Sinbad, why did you invite me here?
I symbolize officials throughout Maryland that have conflicts of interest, and I want to persuade you to support my ethics ordinance.
But, Captain Sinbad, I heard your new ordinance is weaker than the old one. Intrusive disclosures, but weak on ethics. So what are you really up to?
I want to cram through an ordinance that prohibits conflicts of interest for everyone except me.
Oh, that explains it. Now, I know why you weakened the definition of the term business entity, so it now permits conflicts within government. You deliberately made the ordinance weaker when it comes to protecting taxpayers.
Whoa, mate. You weren't supposed to notice that change. Caught me with me hand in the cookie jar. So what? Why do you care if I still get to be the captain and I also get to vote on departmental budgets that pay salary increases to my own family members?
If you were voting on a private sector contract that benefits your own family members, wouldn't that be a conflict of interest?
Yes.
But are you also telling me it allows you to fund contracts within government that benefit your own families?
Yes! You've got it. Checkmate.
How about employment? Are you telling me a commissioner cannot generally fund a private sector company that employs him, but can fund a government agency that employs him?
Yes! I just love being captain.
That doesn't seem right. It appears to jeopardize your impartiality.
It ain't right, but I aim to make it legal. I'm going to pass an ethics ordinance that is both fair and biased.
Wait. Did you say fair and biased? What does that mean?
It means it is fair for officials that hold a second job inside of government, but biased against the officials that hold a second job in the evil private sector. Oops, did I say that?
How do you do that, Captain Sinbad?
Easy. We pass a new ordinance that places restrictions on officials with business interests, but cleverly excludes officials with government conflicts of interest. It is deception through omission.
Disgusting.
Only if people understand it. And second, I appoint people to the Ethics Commission who are related to government officials that also pay me a second salary. Pretty nice insurance policy. Huh. Hard.
That seems like another conflict.
Perhaps, mate, but it works like a charm. Kinda like having the ethics equivalent of a four-leaf clover in my pocket. It takes the term fox guarding the hen house to a whole new level. Ha ha ha.
But Captain Sinbad, aren't there already ethics opinions that say an official shouldn't vote on funding that affects your own family members inside of government?
Yes, but I kept shopping.
That sounds pretty fishy to me. In fact, about as fishy as Moby Dick.
It's only fishy and unethical if we define it as unethical. Besides, I've got the votes to do it. Sweet.
I wouldn't be so sure of that. A little birdie told me that some commissioners agree with Commissioner Rothschild.
Wait, does that mean you won't support my unethical ethics ordinance?
That's right, Sinbad. I stand with Commissioner Rothschild on this one. In fact, I agree with his suggestions. 1. A conflict is a conflict. We demand equal treatment. Conflicts should be defined the same, both outside and inside of government. 2. If officials must disclose assets outside of the county, they should also disclose debts. It should be both or neither. Disclosing assets without debt misleads the public. 3. We need local control to safeguard sensitive information and protect innocent crime victims, including women and children. Finally, because of these conflicts of interest, taxpayers are fully deprived of commissioner representation during large contract negotiations. These conflicts are enjoyed at the expense of taxpayers. This jeopardizes the public's confidence in the impartiality of their government. This is serious and must be stopped. Well, Captain Sinbad, walk the plank, because the taxpayers in this hearing room will not tolerate this lack of impartiality any longer.
Oh no, no, oh no.
Enough. Write the commissioners at commissioners@ccg.car.org. Tell them fix the unethical ethics ordinance. That's commissioners@ccg.car.org. Commissioners@ccg.car.org.
But I won't quit my day job. Okay. So let's get into something more serious. I hope that gave you a general sense for where I'm at. I actually want a stricter ethics ordinance because I think we've got some problems that have developed over the last few years, and they're not unique to Carroll. They're happening in other counties as well, like Frederick County. So I entitled this presentation, An Ethics Ordinance That Still Needs Work. Now, some commissioners have argued that conflicts of interest are okay as long as they are disclosed. That's wrong. Our current and the proposed ethics ordinance both state that people have a right to be assured that the financial interest of holders of and candidates for public office present no conflict with the public interest, and the people have a right to be assured that the impartiality and independent judgment of public officials and employees will be maintained. So what's been the history of ethics opinions over the last few years of commissioners with dual employment, where they're commissioners and they hold other jobs within government? Let's take a look at some actual opinions that have been issued and see what was actually said. These have all been redacted in order to comply with disclosure requirements. We will not talk about any specific individuals, and please don't shout out any names because I will neither confirm nor deny. I will simply not say anything. In 2008, there was an ethics advisory opinion issued for a commissioner who was also a substitute teacher. And on the right, you can see what it says. That opinion was March 7, 2008. It said that this individual should not hold dual employment as county commissioner and any other position funded by county government. His doing so is a violation of the ordinance, and he was forced to take his name off of the list to be a substitute teacher and be only a commissioner. Bravo, a common sense ethics decision that I think most of us would agree with. I see the heads nodding yes. You can't do both. You can't fund yourself. There was a Board of Education advisory opinion that was released in 2014. Did it say that a commissioner who is a school employee can vote on a school budget? Which, again, I think is a correct decision. Well, again, I think this opinion got it right. If you look at the underlined in red, it says at the very top line, it could violate the provisions of the ethics policy because they have the potential to affect him personally. And then if we go down to the box at the bottom, can I see? Can't get to it. In the bottom, it says, as such, the panel would suggest that Mr. X abstain from voting on such measures that would have an effect on him so as to avoid the appearance of impropriety or self-interest. And note it says to avoid the appearance. You don't have to actually have an impropriety. If it appears to be an impropriety, it jeopardizes the public's confidence in the impartiality of their government. 2016, the Attorney General's Office issued an opinion. Did it say that a school employee can vote on matters affecting the Board of Education? Well, he says there were two questions. First question is, could he in theory hold both jobs? Well, yes. They're not necessarily incompatible. I don't really agree with that, and I'll show you why in a minute. But then he raises the question about whether or not he can vote, and he says, we offer, on the very lowest box, we offer no opinion on that issue. We offer no opinion on that issue, on whether he can vote. So far we're 0 for 3 in terms of saying that you can vote. Now, and then in 2016, the rest of the AG's opinion was this conclusion does not address Mr. Blank's duties under the ethics provision. Well, that would be the county ethics organization, and that's what we're here to discuss tonight, because that's what we're debating. Now, what did some prior Maryland Ethics Commission's opinions say about conflicts? Well, in 2001, there was a opinion that talked about barring an official from having any other employment that would impair their impartiality or independence of judgment. Another opinion around 2001, it talked about this idea of competition for agency funding. If you have a daughter who works for one agency, even if this is not going to result in her getting a salary increase, does it create a problem? Well, their point is this: when there are multiple agencies competing for funding, the possibility of favoritism for one agency over another is by itself a conflict of interest, regardless of the level of control by an official once the funds are dispersed. Another opinion, 1984. What if an official gets reorganized in their department and they can prove they have no authority and no control over funds that they've dispersed to an agency? Does that mean it's not a conflict of interest? And they said, no. He said the public would be unlikely to know or understand to what extent reorganization of duties or non-participation would avoid a conflict of interest or the appearance thereof, and therefore it's still a conflict of interest. So everything leading up to this seems to be common sense. Now, we get to the Maryland Public Ethics Law. They had a retreat in September of 2017. The public's ethics law prohibits participation in matters by board members or employees where the board member or employee or certain relatives have a specific interest. So do any of these Maryland opinions that we've covered so far say that a commissioner who's also a Board of Education employee can vote on the Board of Education budget? No. Everything we just covered suggests exactly the opposite, except there's one sealed opinion which I have not been able to see that I understand condone this conflict of interest. But I've got citizens come to me saying, well, Rich, is that even valid? Was that opinion tainted? And I said, why? They said, well, because a member of the Ethics Commission that we think was involved in making that decision, we don't know, but that we think was involved in making that decision was closely related to a member that sits on the Board of Education. And should that member have recused himself or herself from that decision? I said, I don't know. They raised an interesting question, because if there was no recusal, then arguably that decision was tainted. Now, why should we care about any of these things? Because there's hidden damage from conflicts of interest. Let me give you some examples. The theory is we don't really exert much control over what happens with the money once it gets to the Board of Ed, and there's a degree of removal, therefore it shouldn't be prohibited to fund the Board of Ed that in turn funds collective bargaining contracts. But here are some of the issues that come up that are invisible to the public and are not being talked about. Number one, as commissioners, we have the right to budget the Board of Education in 12 different categories if we choose to do so. Several of them are salaries. Well, we can't go there, because if the current board budgeted in salary categories, it would be perceived as breaching the threshold and being a conflict of interest. So taxpayers are deprived of one of the rights that we have. The presence of conflicts of interest prevents the commissioners from availing themselves of that statutory right. Dual employment leads to difficult conflicts invisible to you that damage the proper operation of government. For example, Even a minor conflict of interest by one commissioner can prevent all 5 commissioners from exercising their right to participate as ex officio members within the Board of Education. And this matters during contract negotiations. The county attorney came to me and said to me, Rich, you have to accuse yourself from closed meetings of the Board of Education where there's discussions about contracts. Because if you got involved with those contracts, since you're part of a single body known as the Board of Commissioners, if you know, the other commissioners deemed to know, that would certainly cross the breach into making their conflict mature to the point where it was actionable. So the taxpayers get 0 representation in these closed meetings at the Board of Education. Does that make sense? Understand that? Would you understand my explanation? Yes, it's a problem. It's invisible, but it's a problem. Now, is it true that the Board of Education retains full control over the enforceability of collective bargaining contracts? Well, no, it's not, because the contracts all include a phrase which says this agreement is contingent on full funding by the county commissioners. It doesn't say full funding by the Board of Education. It says full funding by the county commissioners. Now, why does that language matter? Because clearly it's the Board of Commissioners that retains absolute control as to whether or not collective bargaining contracts are enforceable against the taxpayers. Simply stated, it's the Board of Commissioners. We control the on-off switch. We control it. If we don't fully fund, if we fund $1 short, then legally those contracts are not enforceable against the county. That's a conflict. I would argue that the degrees of removal that are being argued as to why a commissioner can fund the school system are specious. They really don't, they're not supported by the facts. Hey, Tommy. So how do we fix this? What's wrong with the ordinance? I think sometimes the best way to help you understand is with a question, to show some examples with questions. So here's a quiz question. Let's go into the ordinance. There's definitions of business entity. I'll give you a hint. One of them is in the old ordinance, one is in the new ordinance. Which of the following definitions from the county ordinance is more likely to prevent conflicts of interest within government? Number 1, which says business entity is any entity, profit or non-profit, organized for any purpose. Or number 2, which says the same thing except it does not include a government entity. Which one's broader? Number 1 is broader. Number 1 provides more coverage for the taxpayers. Anybody want to guess which one's in the new ordinance? Number 2 is in the new ordinance. Number 2. So they've excluded government from certain prohibited conduct that were not specifically prohibited in the old ordinance. Stronger or weaker, the new ordinance? Weaker. How do we fix it? Well, it's real easy to fix it. We just delete the term business and simply define an entity as any entity for profit or non-profit, organized for any purposes, including government. That's what it ought to be. If you can't do it with XYZ Corporation, you shouldn't be able to do it with any agency within government. That's my position. What's good for the goose is good for the gander. No special treatment inside of government. So here's what it would look like. Here's an actual excerpted printout from the new ordinance, which has participation prohibitions, and where it said any entity, any business entity, excuse me, where it said a business entity in which the official employee has control, a business entity where one of your employees work, I propose striking the word business and just changing it to any entity. See how that makes it broader? The restrictions now start to clamp down on government conflicts. There's another new term that was added. It was pointed out to me today. Added after January 23rd when we agreed to send this thing to public hearing. Very interesting, a change that we noticed today after it was voted to public hearing that dramatically weakens it. Chapter 34.08, and I think it's 42D. Let me see. 34.08A2. Here's what it says. This is new. 34082D was added. Employment or financial interests allowed by regulation of the Ethics Commission. Okay, so far okay. If the employment does not create a conflict of interest or the appearance of a conflict of interest, so far so good. And now, here's where we drop the boom, where the financial interest is disclosed. Well, wait a minute. The purpose of the ordinance is to ensure that on the red, the financial interests of holders of and candidates for public office present no conflict. It doesn't say the purpose of the ordinance is simply disclose a conflict. It's to prevent presents no conflict. And here it's now adding a phrase that says, as long as you disclose the financial conflict, you're okay. No, not in my book. I think the ethics ordinance should stop conflicted behavior, not simply disclose it. Disclosing the financial interest alone is not sufficient. And furthermore, this directly contradicts the purpose in the beginning of both the old and new ordinance, which state, we're sure that there's no impartiality and ensure that it presents no conflict. Does everybody see the problem with this? Yes. This is the new ordinance. Why would we pass anything that said this? It's weaker. I want something stronger. Now, there are deterrents in here, too, to people like myself. The disclosures are ridiculous. The address, the street address of every property you own anywhere on planet Earth, well, what relevance is it if, hypothetically, a commissioner owns a property in Hawaii or a condo in Oshkosh, Wisconsin? Who cares? It's not relevant. See, don't confuse intense disclosures with strong laws to prevent conflicts of interest. Don't confuse the two. We need to be going after the conflicts of interest that are allowing commissioners to vote on budgets inside a government where they're benefiting their own family members. So what I propose is we should align them with what's required for the United States Senate. If any of you run for the United States Senate, just give them the city and town where your properties are in, and that's it. They know that giving out the address of your properties makes them a target for mischief, vandalism, arson, you name it. It's not fair. So I propose making the changes in blue. You disclose the nature of the property and location by city or county. However, if it's inside of Carroll County, then you got to disclose the full street address for anything inside the county because that's relevant. Now, how about disclosure of the balance sheet? This is a real big one for me because I'm a businessman. I have an MBA. I've been in business for 30-something years. The proposed ordinance demands intrusive disclosures of what you own, but it doesn't look at the liability side of the balance sheet. It says, just show us one half the balance sheet. That's ridiculous. Why does it matter? Let's give an example. Why debts matter, for those of you who maybe are not financial people. The current ordinance, the new ordinance, only looks at assets. So let's say two candidates want to run for commissioner. One says he has assets of $300,000. One says he has assets of $50,000. Who looks stronger? The one, A, right? He's got $300,000 in assets, right? Now, what happens when I disclose the liability side and you see that candidate A actually has $400,000 in debts and is actually upside down. He's insolvent. And candidate B has no debt. Now who looks stronger? B. So when you don't disclose both sides of the balance sheet, what you do is you deceive the public. You paint an inaccurate view of what that person's been doing with their personal finances. And I can promise you this, whatever they're doing to themselves, they'll do to your government. Okay. Now, don't take my word on it. Here's a letter that talks about the effect of debt on military clearances. And I myself used to hold top secret special intelligence. I know what they care about. They don't care about what you own. They care about what you owe. Because if John Doe owes me $50,000 and John Doe is a commissioner, I can say, Mr. Doe, you're going to make sure I get that contract. Because if you do, that debt might disappear. No paper trail, no audit, no checks, no cash under the table, no driveways being paid in remote properties. It's completely invisible. The easiest bribe in the world is forgiveness of debt, and we don't require it, except inside the county. It's ridiculous. So here's what we said about military debt. The issue of security clearances and debt is a sensitive one for the U.S. military because a soldier in debt is considered more open to bribes or accepting money in exchange for revealing secrets. And I assure you that an official that's in debt is more open to accepting bribes or accepting money in exchange for doing favors. That's where the conflict of interest is. Don't show me what you own. Show me what you owe. Because that'll tell you what they're going to do with your government finances. So my recommendation, disclose all debt above $20,000, whether it's inside or outside the county. I don't want to drive Commissioner John Doe crazy every time he charges up something, buys a piano for $5,000 on his credit card. But if it's over $20,000, inside or outside the county, you got to disclose it. The public has a right to know who owns you. Remember what it says in the Bible? The debtor is what? Servant to the master, the lender. The debtor is servant to the lender. We should be requiring those disclosures of debt. And here's something else that's missed in the new ethics ordinance. Medical bills need to be fully exempt. HIPAA. There's no provision for exempting medical bills in the current one, even for bills inside the county. We must exempt medical bills. It's not fair to have forced Commissioner John Doe to disclose that his wife has just had $100,000 of cancer treatments. That's not right. And we should not be excluding retail credit cards. Somebody goes to Las Vegas and charges up $50,000 on their Visa, playing the slots. I want to know it. As a voter, I have a right to know it. I want to know who's misbehaving with money. It's the liabilities that show it. Additional recommendations. We have some minimal level of local control right now over disclosures. There are conditions where it doesn't make sense to disclose something. We should retain local control over disclosures that could place the life or safety of a crime victim at risk or some other exigent circumstances. If, God forbid, John Doe's daughter is a target of attempted rape and she goes off to college and her assailant is about to get out of jail, maybe the parent don't want him to be able to find out where their daughter's living now because he threatened to hunt her down and finish the job. There needs to be a contingency to allow the Ethics Commission to suppress certain data when there's exigent, documentable circumstances. Okay? There needs to be a contingency, and there could be other circumstances too. You know, you could have somebody that you testified against in an unrelated trial, and he says, "I'm going to burn your buildings down." Well, maybe we shouldn't force the disclosure of those buildings. Maybe we disclose them sealed within the Ethics Commission itself, and they keep them sealed. Still discloses them, but they're sealed. It's called an in-camera disclosure. None of this sensible stuff.
What would be the purpose of disclosing them sealed when the entire purpose of the whole thing should be that it's transparent?
I'll second that, but I have to get 2 other votes for this, so I'm trying to offer compromise solutions which everybody can live with. And see, there's no attempt to hide anything here. It's an attempt to do this right. Ladies and gentlemen, passing an ethics ordinance is just like anything else. You can do it right, you can do it wrong. This current thing is not good. So, conclusion. The draft ordinance can be quickly fixed with 5 easy changes. Number 1, we need to have balanced disclosures of assets and liabilities, assets and debts. Let's balance them out, okay? Show both sides of the balance sheet. Otherwise, we're deceiving the public. Number 2, the prohibitions that apply to the private sector should be applied similarly to government. We shouldn't have fancy language. We'll be making language changes that make it easier to have a conflict of interest within government. Number 3, the idea that if you simply disclose a conflict of interest, you fulfill the requirements of this section is ridiculous because it clearly states the purpose of it is to assure the public of the impartiality. If I disclose to you that I own 10,000 shares of stock in XYZ Corporation, then I vote to give it $1 million in grant money, I don't think I've assured you of my impartiality. I may have disclosed, but that's not enough. This has got to be removed. These conflicts need to be abated, not simply disclosed. We need to protect sensitive information for crime victims and other exigent circumstances. I've already discussed that. And most importantly, we need to make sure that the language in the ordinance prevents any member of the Board of Commissioners from exercising their, it should not have a conflict that prevents any member of the Board of Commissioners from exercising their full statutory authority as ex officio members on the Board of Education or any other board within the county. Why do we need to fix this ordinance? Well, to reduce conflicts of interest. Not just to find out whether some commissioner owns property in Oshkosh, Wisconsin. We need to fix the conflicts of interest. Number 2, we need to eliminate barriers that will prevent good people from running for office. When the disclosures get too bad, successful business people say, "I'm not going to put up with this, I won't run." And number 3, to ensure the financial disclosures are balanced and show a more accurate picture of of an elected official's situation. Let me summarize. We've gone astray. We're watching decisions being made that are taking the ship of course, which is down a path of common sense towards preventing conflicts of interest, and we're moving it in some direction that's bizarre. Where now we have rationalized that conflicts that defy all of our sensibilities from a common sense perspective are now being legitimized. It's ridiculous. We need to fix it. I'm committed to fixing it. But it's hard to fix it when the county's polarized. I think the people that think that I don't want to get a good ethics ordinance are really misreading me because I really want a good one. I want a real strict one, probably stricter than they want. So I'm not sure that I'm necessarily at odds with the people who have been opposing me, and I know that the rest of you all agree that we need to straighten this out. And with that, I'm going to open it up for questions for the next 5 or 10 minutes. I'll take Catherine first. Come to the microphone, if you would. And why don't you start, Scott, while she gets to the microphone? Why don't you line up behind the mic? Go ahead, Scott.
Rich, does the current piece of legislation, does it define what a conflict of interest is?
No.
That's a problem.
Yeah.
When you said that addresses within Carroll County should be disclosed, would you still propose an exemption for crime victims, especially victims of domestic violence, to shield their addresses? How would you?
I don't know, Catherine. I haven't thought that one through. I generally, I think that the people of Carroll County have a right to know what properties you own inside the county, because you'll be making decisions that affect them. I'm open to hear what are your thoughts on it?
Through a sealed, well, the state is currently entertaining legislation statewide, so it would put, actually, if it passes, we'll put the county, if it passes this, in conflict with the state, which is doing much more shielding on addresses of victims, especially of domestic violence, of which I am one, because when that abuser gets out of jail, they go look up that property, and you're in danger again. But again, it could be in a sealed, so you have an exigent circumstance somehow. I thought that's what you were proposing.
I think it's the best compromise, Catherine. I think that saying, look, I've got something sensitive, you should sit down with the Ethics Commission, you show them the documentation, whether it's police reports, judicial records, and you say, see, I've got a problem. Would you mind if I didn't disclose the property address list rental? And they say, okay, we'll seal it. But you can't vote on anything related to X, Y, or Z. Harold?
Commissioner Rothschild, I just want to say that you do an unbelievable job, and that what you've put together. I don't know what the other commissioners have to represent their positions, but you've made it very clear where you are, and I thank you very much.
I thank you for that, Howard. I do want to say, I think that some of the other commissioners, I'm not going to lie, but several of them are really good men, and I think they want to do the right thing, and they made some overtures towards me, leading me to believe that they're willing to reconsider some of these things, because it's just common sense. In fact, I would argue that they affect both sides of the aisle, Democrat and Republican the same. I don't think we have to be on opposite sides on some of these. Jane?
I have two quick questions. One is, I noticed that the amended charter chapter that was on the website was most definitely not the original chapter edited. It was a completely brand new draft and then had further edits. So it's literally twice as long as the old chapter. You're aware of that, right?
Well, yes, in the effort to rush this through, because some of the commissioners felt duress because they were trying to please their constituents.
Okay. Second question. Because I think a lot of people are misled, and they think the only changes are the things in red if they went and looked. No, the entire thing is different, completely different. So along that line, I was reading through, and I noticed, and you haven't brought this up, and nobody I know has brought this up, it seems to give new powers, lots of new powers to the Ethics Commission, while at the same time allowing the Ethics Commission to be, not as removed from people in government as it used to be. But the point is, it seemed like they are allowing for regulations, like the Ethics Commission can even make sort of regulations, even though they're not given explicit authority to do so. There's language in there that seems to indicate there will be regulations of some sort, exempting certain things, changing certain policies. And I just want to point out to you, which you haven't talked about at all, but it seems utterly ludicrous because there's no authority in there to actually do it. And I cannot imagine a turn of events where an ethics commission appointed by the commissioners will then be allowed to pass regulations which the commissioners must obey.
Well, actually, I deleted thank you, Jen. I deleted a slide which talked about the fact that when officials who are regulated by an ethics ordinance get to pass the ordinance and appoint the officials who will enforce the ordinance, that's pretty much a conflict of interest in itself, and suggested that really these things should be moved to another organization outside of the county. Yes?
First of all, just a point of information. In your introductory remarks, you made reference to commissioners in Frederick County. I'm sure you're aware that Frederick County does not have commissioners.
Councilman, thank you. Thank you, Karine. Thank you. Councilman.
I'm just very curious, and maybe I'm confused. You have been commissioner for over 7 years. Is that correct?
Yes.
And if you feel this strongly about an ethics ordinance, why or have we not been hearing from you these last 8 years that something needs to be put on the table and strengthened?
Well, it's been in front of the commissioners 4 or 5 times now since 2000. Every time we send it back down to the Ethics Commission and at the state, it gets shot down. And then there's lots of tension on the Board of Commissioners because some people would stand to be winners and some people on the Board of Commissioners could be losers depending on how it's written. So there hasn't been much of an appetite of any of the commissioners to tackle it until now. And I had people asking me to work on it prior to this. And I said, I'm going to wait till my last year in office. It's just going to too contentious, and I just don't feel like getting into a fight with my fellow commissioners that I have to work with. So I said, people, give me till close to the end of my term, then I'll bring it up. So here I am. Fair enough.
First,
No, I'm not running for office again.
well, you will have to disclose in the past. That's how the law is
Yeah.
written, correct?
Yeah.
Okay.
But I have no conflicts. That's everything clear. I disclose everything I have inside of Carroll County, so I have no conflicts. And that's what the current ordinance requires. Any other questions or comments? Okay, so let me do this because, okay, I'll get you last. Before I take the last speaker, after we're done here in a minute, you got to go downstairs. We need you downstairs at 7 o'clock because that's when the actual formal hearing is going to take place. We need you to go downstairs at 7 and speak up again, because that's where the commissioners will hear you. If you don't speak up, then they'll assume that what they're doing is okay. Okay. Okay, last comment? Microphone?
Okay. I was just curious. You mentioned that the commissioners had final say in the arbitration, the contract negotiations. Let's just say, for example, the teachers, okay? Who negotiates our side? Because the taxpayers are always paying the bill for this. Nobody really understands that.
Let me quickly, the Board of Education engages in negotiations with help from the superintendent and the staff. But the Board of Commissioners has a right to participate in those closed discussions as ex officio members, but we can't. That's the answer. But we do control the contract state that they're contingent on us fully funding them. And with that, I'm going to wrap it up because I want you to get downstairs in the next 4 minutes. Thank you very much for coming.
Do we have to sign up to speak?
Downstairs, yes, go sign up to speak. Run down there in room 003 and sign up. Thank you for coming, everybody. Downstairs in room 003. Thank you.